I want to thank everybody for showing up today to our press conference. My name is Andy Seelick. I am the Executive Director of the Minnesota Voters Alliance. We appreciate your time today. I just want to take a few minutes to give a summary of what we're doing to try to give you a perspective on what we've been working on for almost 5 years. So we're really excited to be able to share this with you. Now, first and foremost, I just want to say one of the reasons we started looking at Minnesota's elections and starting to really think there was a problem is when we started studying the statutes and what happened or what happens regarding same-day voter registration. As many of you may know, there's only a handful of states in the union that have same-day registration, and Minnesota is one of those states. What happens in Minnesota? Most people are alarmed when they hear how Minnesota handles their same-day voter registration. In presidential election years, an average of 540,000 people in Minnesota register on election day and vote. And one of the things we learned is that the voter registration applications that those people fill out are not even entered into the statewide voter registration system, the SVRS, until 42 days, up to 42 days after the election. So all the checking and the eligibility verification that the Secretary of State does, Mark Ritchie admitted approximately a year ago that they, in a Capitol Report interview, that they do 8 different checks to 8 different databases. They make sure they're not a felon. They make sure they're not under guardianship as mentally incompetent. They make sure they're a citizen. 8 different checks, plus they send out a PVC, postal verification card. So the Secretary of State does 9 different checks for anybody who pre-registers 20 days before the election. So when the people of Minnesota hear that 540,000 people aren't even being checked until months after the elections and the elections are certified, they are alarmed. And that's really what why we have dug and dug and dug and dug to identify the problem, which I believe that we have done. So with that little introduction, that is my little reason for getting involved and why our organization has been involved. Today, the Minnesota Voters Alliance and co-plaintiff, former Representative Kirk Stensrud, Eden Prairie, right? Yes. He'll be speaking next, and then Carter Glendenning on our board, and then our attorney, Eric Cardo. So my little presentation here, bear with me, is only about 3 minutes. We're announcing today the filing of our legal challenge against Secretary of State, Steve Simon, and county election directors from Hennepin and Ramsey County for election officials for entitling and permitting persons to vote who are known to be ineligible by the state. That is the key in our lawsuit. We're not targeting people they don't know anything about. We're targeting people that they do know something about, and I'll cover that in just a moment. This petition is being filed under the Minnesota Errors and Omissions statute against the Secretary of State regarding wrongful acts, which, quote, out of the statute, have occurred and are about to occur again. Article 7, Section 1 of the Minnesota Constitution categorically and expressly prohibits certain individuals from being entitled and permitted to vote. And I handed out the Minnesota Constitution. Did everybody get a copy? It's pretty crystal clear what the Minnesota Constitution, your Constitution, says. On Election Day, the Secretary of State wrongfully directs, instructs, demands that election judges, via the Election Judge Guide, tells them to permit persons known to be ineligible to vote, such as non-citizens, convicted felons, we'll talk about that in a minute, and vulnerable persons who have been exploited by political predators, who have been found by a court to be mentally incompetent to vote, comma, as long as they swear they're eligible. I wish I had more time to get into that issue, but I don't today. Without any legal authority, election officials allow the self-certification to supersede an adjudicated court order. Despite the court order, election officials reinstate the right to vote and permit the person to cast a ballot and have their ballot counted, despite of a court order. When the Minnesota Constitution says that felons, and you folks, I believe, have a copy of this, shall not be entitled or permitted to have to vote at any election in this state, it must mean something. When Minnesota Statute 201061 says that ineligible persons may not register, it must mean something. And when judges throughout the state restrict the right to vote of those convicted of a felony, that too must mean something. The Secretary of State's actions contradict the express language in the Minnesota Constitution, which I just handed out to you a few minutes ago. Even if a statute or policy allows a person to self-certify in the belief that they're eligible, the certification cannot be a governmental justification to permit the person to vote because the election official knows of the judicial adjudication that the person does not have the right to vote. Thus, under the Minnesota Constitution, the court-ordered restricted right, the court took away their right, precludes any official from violating or from considering the person an elector. Minnesota statutes require government agencies to report to the Secretary of State those persons who have been convicted of a felony, as Susan well knows, right? We've done a lot of homework on this. Susan has worked a lot on the felon voting with us. So the Secretary of State, the state agencies such as the Court Administrator and the Department of Corrections are required by statute 20115, 155 to do what? To send lists regularly to the Secretary of State of all persons who have been adjudicated a felon and have lost their right to vote, okay? And in Minnesota, that right is lost until they finish their sentence, okay? That's kind of another issue, but that's the policy, and we think that's a good policy. When a felon proves that they can live by the same laws we're all having to live by, then they can vote. Some states take them away for good, those voting rights. Okay, thus, almost done. The Secretary of State and election officials attain knowledge of persons with court-restricted rights to vote, and the same under guardianship. For example, data received from the state court administrator, we were able to get data from the state court administrator, shows 105,000 felony convictions since 2003 were sent to the Secretary of State. Those notices were sent between 2003 and 2014. Yet, notwithstanding the election officials' knowledge of those court orders, which we have a box, and Eric will talk about that, the attained knowledge is abandoned on election day. In other words, they ignore it. That's how Minnesota handles people with restricted voting rights. The state's own data reveal the magnitude of persons without the right to vote statewide can be significant and capable of influencing election results and usurping the will of the people. We learned from one of our many Data Practice Act requests, we had a Data Practice Act request that we submitted after the 2008 election. 542,000 people registered on election day. We wanted to know, of those people, specifically of the people who registered on election day, how many of those people 12, 18 months later, after they've gone through the checking process, albeit too late to influence the election, how many of them had their status, their voter status in the SVRS changed to something other than active? The statewide voter registration system, all of you people, I assume, are eligible voters, so you would all be in the system and active. When the state does their checks, if they find out you're a felon, the Secretary of State sends that to the county auditor, and then you're marked challenged on the roster, challenged felon, or challenged residence, or whatever the case may be. 17,000 same-day registrants after the election were marked challenged. They wouldn't tell us who they were. They would only give us the aggregate number. Folks, that's a lot of people. That's a lot of people. The U.S. Senate, Obamacare, was decided by those 300 votes. So that's significant. And we're not here complaining about that. What we're here for is election integrity, so that people in Minnesota can have confidence in their election results, not like some third world country, which is what we have today. The appendix in our lawsuit contains over 5,000 pages of documents, if you can believe that. That's one of the boxes right there that Eric will talk about. 5,000 pages were scanned in. And they'll be available on our website in the next probably 48 hours, which you folks will be able to see everything. And including those documents, affidavits, over a dozen affidavits, and other supporting evidence, such as court records on several thousand felons who voted illegally that we've identified in 2008, 10, 12, and 14, which we're finding out has grown, actually. And those actual numbers will come out tomorrow because those were all just scanned in, and now they're double and triple checking everything. So it should be all done in the next day or two. According to the state court administrator, approximately, or only, 250 of those felons were convicted of voting inelligibly. Folks, do you know why you hear a lot about voter fraud is low in Minnesota? Do you know why? Why is because the only way to get convicted of voter fraud in Minnesota is if you're stupid enough to admit that you shouldn't have done it. I'm sorry to say that, but that's the law in Minnesota. So of those people who were convicted or who voted inelligibly, 250 approximately admitted that they shouldn't have done it. So maybe they're just good, honest people. I take that other word back. Okay. But that's still a lot of people that the state had to spend taxpayer money on going to convict them. If they would do what we're simply asking is don't give them a ballot. Save, not only improve the credibility and integrity of our elections, but save taxpayer money at the same time. Okay. But the only reason those 250 were convicted was, number one, that the felon had to admit that they knew they did it illegally, and because of the great work that Dan McGrath and Minnesota Majority did, digging into those databases and doing extensive comparisons, and we've done the same thing for 12, where they had to get the Bureau of Criminal Apprehension database, the whole BCA database, and the entire SVRS, and have a professional database person match them. Very sophisticated stuff. And then when they matched, they double, triple, checked them, then they sent them to the county auditors or the county attorneys. And if it's not for Dan's work on that and his group, there wouldn't have been any convictions. So, and we even, on our radio show at the Ramsey County Fair, we had John Choi on, and he admitted it's just not a priority for them. So just to be clear, our primary interest is not about voter fraud, folks. It's to stop ineligible voting. I mean, regardless if a person knows or doesn't know if they're eligible. Our petition seeks an injunction against the Secretary of State and election officials, requiring them to stop providing ballots to persons known not to have the right to vote under a court restriction, stop counting any ballot of a person who has his or her right to vote court restricted, and 3, on election day, prohibit the use of self-certification, in other words, the oath, as a basis for permitting persons who have been identified by state agencies to the Secretary of State or other election officials as known to have their right to vote court restricted. Our petition is narrow in scope, as I was explaining, Dale, a minute ago, very narrow, seeking to cure state and county election officials' specific wrongful acts involving only those persons known to have their right to vote court restricted. So that's what this lawsuit is targeted on. The petition does not reach, nor does it attempt to reach, issues regarding treatment by government officials or any other class of persons, such as those persons who have the right to vote or those persons whose right to vote is unknown. In this petition, we also propose simple, effective, comprehensive, inexpensive corrections for these errors, such as simply implementing a system that is currently used to check if someone voted absentee. Persons with court-restricted voting rights are just as ineligible as someone who voted absentee, if you think about it, right? For all you election judges in the room, when someone votes absentee ballot, they'll put AB on the poll roster. So if that person comes in to vote, they'll say, sorry, Mr. Smith or Ms. Smith, you already voted absentee, you're not getting a ballot today, okay? To us, to me, there's no difference in that person than the person who has a court, the judicial system has taken away that person's right to vote. Are they any differently ineligible? And so we already have a system in place. They don't have to spend a lot of money implementing what we're asking for. Persons with court-restricted voting rights are just as ineligible. I already said that, apologize. Getting down to the last page. I have always felt strongly that America is the greatest country in the world. That's why I joined the Marine Corps when I was 17. That was a long time ago. But to this day, I still get chills down my spine when I hear the Marine Corps hymn or the Star-Spangled Banner. election integrity is vital for America to continue its greatness. I'd like to close with a quote from Hennepin County District Court Judge Jay Quam. What he said in a 2012 case regarding guardianship and assessing wards as mentally incompetent in voting, in which we played a major role in that. This is from Jay Quam. For all the blood spilled and the lives lost, to preserve key tenets of our democracy, such as the right to vote. You ready for this? Courts must do their part to protect the integrity of each vote. This is the key. This is from Jay Quam. The court's obligation to the electoral process is twofold, okay? Two things. One, courts must ensure that every citizen entitled to vote is allowed to do so. How could anybody argue with that? Anything less deprives that citizen of a fundamental right, and it deprives the citizenry of a true democracy. Number two, courts must also ensure that no person votes who is not eligible to vote. Pretty simple stuff, right? Anything less, Quam goes on to say, dilutes the fundamental rights of the proper electorate, and it likewise deprives the citizenry of a true democracy. So folks, very soon, the Minnesota Supreme Court will have the opportunity to weigh in on this important issue and fulfill that obligation that Judge Quam talks about to the electoral process. Thank you.
Thank you, Andy. My name is Kirk Stensrud, and I am a former state legislator. And as a former representative, I'm especially interested in seeing that close elections are fairly decided. In the short time I was in the House, there are a lot of elections that go on that are decided by 1, 13, in my case, 41 votes. And the subject that Andy's brought up, it's very critical that we know that we're not disenfranchising folks who have voted and have the right to vote and diluting that, but with those who don't have that right. So if election officials are not stopping those who have the voting rights taken away by the court, it seems then that Minnesota may not be stopping any ineligible voters. I don't even know if I lost my race and the votes with the votes of eligible voters. So candidates who lose by small numbers have a special need for this information from election officials, and they don't currently get that. And I'm hoping that this can be changed through this action. The state does not check the eligibility on election day registrants until after the ballots have already been counted, and does not release enough information to a candidate so that they can do their own checking. So it's my hope that the courts can get a chance to get this straightened out. Thank you.
Hello, Carter Glendenning is my name. I'm with the Minnesota Voters Alliance, and I'm also been a follower of honest elections since the year 2004. And what I'm going to be talking about is actually actively involved in Kurt's campaign relative to things I saw going on. But first of all, I'd like to say this. Heads up to you Minnesotans, not only those here in this room, but hopefully will be broadcast tonight. Your vote is being compromised by non-citizen immigrants voting in Minnesota. In 2012, I was manning a booth, the voter Yes ID booth at the State Fair. At that time, people were coming to me and asking whether there was an issue. And they stood there in disbelief that there was an issue, as I pointed out in many instances. It's very easy to do unless the election judges are fully trained. In Ramsey County in 2008, I was an election judge over there. And the policy back then was to disregard if they presented a driver's license that said status checked, just to disregard that. Well, here we are. I asked many people listening here if they know the significance of the driver's license having that statement, status checked. status checked. I ask you folks out here. I know many election judges during the 2014 election didn't. As a poll challenger in the Glen Lake Elementary School in Minnetonka, which Kurt Stensrud here, that precinct served him, where he lost by a few votes. The election judges there acknowledged that they did not know what the status check meant. I find that a very important issue relative to the outcome of that election. In addition, I also was a poll challenger at the Glen Lake home, senior citizen home, again in Kurt Stensrud's district. There I saw the head election judge who is sitting, typically what they do is they'll sit right at the registration desk, same day registration check desk. And I was sitting behind her and I saw her signing in somebody who presented this driver's license that said status checked. So I challenged her and she challenged me back. And then she got her mentor, her activist mentor to come in, who was a friend of mine. I know who she is. So I said to that person, I said, well, let's call the city of Minnetonka city clerk on the phone, which we did. And the city clerk educated those people that the word status check does mean something. And what it means is that they're temporarily in our country. That does not give them the right to vote. One of my concerns is when people go up, whether it's Ridgedale or Southdale or the other places, and they actually get that license, they're not really educating these people what status check means. And they're also, it's obvious that many of the election judges have no idea or forget for whatever reason what that means. Until the state changes its laws and rulings, there will remain many voting foreigners who have already been registered and have been cleared to vote because nobody looked for this status check. And that just emphasized what Andy said earlier, that once you're in the pool, once you're on the main ballot, you just can continue voting because they won't ask for the ID card. So I'm concerned that there are many people out there that are illegally voting. And I ask you to remember your vote's being compromised by these non-citizens voting. That is to say, it takes your vote away. We need the state to be honest administrators of the law. And I thank you very much for your time. Thank you.
My name is Eric Cardall, and for those of you who don't know me, I think the Winona Daily got it right. Recently they said he's a lawyer who made a career out of suing the government. And that'll probably end up being my eulogy. So anyway, for you that know me, of course, I've beat the government in 25 different subject areas. This includes townships, counties, school districts, the state, the federal government, you name it, I've sued it, and I've beat them in different subject areas. And so how this works with dedicated organizations and clients like Andy is I have clients who are patriots. They care about government operating well. They see a problem, and they research. This is the formula when they come to me with a legal issue, and we vet, and we vet, and we vet. This has taken 4 or 5 years. This is a lawsuit where we're not new to the subject area, and neither is the government. 2 or 3 lawsuits have preceded this one on similar related issues, and we've learned from those lawsuits. The courts have learned from those lawsuits. Judge Quam was quoted here. Judge Quam recognizes the importance of court-restricted voting rights, those court orders being respected by our administrative officials. So let's get this right, that the state judiciary says this person can't vote, and then over here the Secretary of State and the election judges let them vote. Is that the type of country we want? And we're a country that rebuilds the I-35 bridge when it collapses. We send up a space shuttle after one collapses, right? Well, we have an election system that's collapsed, but we just don't let it go. We rebuild. That's why we rebuilt the bridge. That's why we sent the shuttle up again. And so we have to decide to rebuild right now. And we build that around election integrity, which Minnesota Voters Alliance has defended since the beginning. So now we're filing an errors and omissions petition in the Minnesota Supreme Court. That means when we file the petition with the supporting database that Andy talked about, there's just going to be one hearing in the Minnesota Supreme Court, and the Minnesota Supreme Court gets to decide. Now, why does the Minnesota Supreme Court have original jurisdiction? Well, statute provides for that, and we have to point out the error and omission in the system. Well, after all this vetting, think of how narrow this claim is. Less is more. This is so narrow, right? It's narrow in the sense there are court orders that say this person cannot vote, right? The consequence of a felony conviction is the felon cannot vote. And then they're allowed to vote under the self-certification method. Now, under the law, the court administrator and these other agencies report the ineligible felons to the Secretary of State over across the hall. That information doesn't get down to the election judges to stop those people from voting. They can still vote by self-certification. Now, the law, which Andy read, is very clear. In statute, in the court order, in the Constitution, felons will not be permitted to vote. So this isn't about law. This is about the Secretary of State making excuses about allowing ineligible felons to vote, or ineligible wards under guardianship orders restricting their right to vote. It's about the same thing. What the Secretary of State will tell you, and you should not believe him, is that the Secretary of State will say it's all very complicated and we can't follow court orders. I mean, sure, the court administrator and these other agencies send us the court orders. Sure, we recognize that these people can't vote, but that person's showing up and voting. Just like Andy was saying, it would be like I grew up in Redwood Falls, Minnesota. What if the city of Wabasso and the residents there were allowed to vote twice? Well, we'd all be up in arms. That can't happen. My vote's being diluted. Well, these felons aren't supposed to vote once, and they're being allowed to vote. When in the 2008 race, there were 800 admitted felons who voted, and the margin of victory for Mr. Franken was 312 votes. When we look back, the problem has not decreased, it's increased. Someone's winning elections because felons are voting. Mr. Stensrud here doesn't know after his close election whether he lost among eligible voters because his electorate is polluted with ineligible voters. With respect to gathering the data for this lawsuit, no cooperation from the Secretary of State. The Secretary of State knows these ineligible voters are voting because they're noted inactive in the next state registration system check, but that information wouldn't be shared with us because that'd make it too easy for us. So what we had to do is do reverse engineering. Here's the box. So why are court-restricted voters easier to prove than non-citizens and these other things? Is because there are court registers on the computer. So you can go to the court register for every voter in Minnesota and you can determine whether they're ineligible to vote because of the felony conviction. Right? We can do that. But we pay the court administrator and other officials to do it for us and tell the Secretary of State. The Secretary of State doesn't communicate to the election judge and won't share the information with us, so we have to do it this way. This is why we're going to win the lawsuit. It's because people see what's happening. People see that there are election registers and these people are felons. Then they see rosters where they voted. And how is it that people vote when there's a court order saying they're restricted to vote? And we know that judges, and they should, think that the world depends in part on court orders, right? Where am I going? I'm going to judges. And judges think court orders are important, right? Of course they do. And the judges are going to say that the consequences of court orders are important. Of course they are. And so the justices of the Minnesota Supreme Court are going to look us all in the face and say, well, of course, our court orders must be upheld by administrative officials administering the elections. And so all we've done, all Andy's done, is gone to the computer system. He's pulled up all these court orders saying these people are restricted, ineligible to vote, and then he's proving that they voted. And it's polluted the election contest since at least 2008, where our research goes back. And as Andy said, we're talking about thousands of ineligible voters, 2008 through 2014, but there shouldn't be one. And it's a problem that's been raised over and over again to our government. And here we have the people taking a shot. That is a petition, Arizona mission petition to the Minnesota Supreme Court to manage the government out of its illegality. Right? So it's a cultural problem. The government has a cultural problem, and they don't see a problem The Secretary of State doesn't see a problem with ineligible felons voting and determining elections. We, the people, say, no, there is a problem with that. So we're going to use this route, this little petition, this paperwork. We're going to present it to the court, and everyone in this room agrees with me that ineligible voters should not be allowed to vote. So if everyone in Minnesota agrees, except the Secretary of State, that ineligible voters should not be allowed to vote, then we're going to win this petition, right? Well, it's not that easy, right? It's not that easy. And the reason it's not that easy is that it's difficult, it's challenging for a court to hold the government accountable to law. And we understand that. It's a difficult job being a judge, but when we lay out things so well, so simply, we would hope that the court would do the right thing. And I really respect the Minnesota Supreme Court and the justices there, and if they just see it as what this petition is, and this is simply what this petition is, justices, we want your court orders honored through the other branches of government. And justices, when you affirm a felony restricting a person's right to vote, the election officials, including the Secretary of State, must honor that court order. If that court order isn't honored, we are not ruled by law, and our elections are not full of integrity. It's the opposite. If you believe in the America that we believe in, you believe in this lawsuit, and we're going to win in the Minnesota Supreme Court, not because we're above average, not because we're extraordinary, but because we're right. And the right can prevail, and this petition is an example where everyone needs to share the information about this petition, because if we don't win, then there's something really wrong. Thank you so much, and we'll take questions.
I want to invite Dan McGrath up here. Actually, when Eric was giving me the credit, that's 2008. This is really the stuff Dan started. So do you want to say a couple words, Dan?
Thanks, Andy. Well said, Eric. Very good presentation. Thanks for all your work you've done on this.
Building on your work, Dan. I appreciate it.
You're doing really good work. Thank you. Couple quick comments. First, I want to say how proud I am of all the volunteers that did the research that led to this, and express my frustration that it takes citizen groups like ours to do this kind of work. We elect people. We pay people a lot of money to run our government, and they're not doing this work. They don't seem to care. It's just a very frustrating situation for me that it requires citizen groups like this to police our own government. That's all I have to say. Thank you.
Thanks so much, Dan. Are there any questions? We can take a couple of questions, and then for those of you, how many are going to Old Mexico afterwards? All right. Okay, good.
Andy, fine.
We got to make sure that anybody who's not, we have a handout for you so you can take some information with you. Let's see, Liz might have. Do you have envelopes on it? Okay, sorry, go ahead.
What's going with the Supreme Court hear this case?
Eric? I don't know. I have no idea.
Yeah, but my guess is that there'd be a briefing schedule issue. This is for similar cases, and then it would be heard in 90 days.
Dave?
Does the Supreme Court have the authority or right to, like in a lot of cases that are brought before the Supreme Court, they have a right to decide whether they even want to hear it. So is this something that they have to hear in this errors and omission action that you're bringing, or is it something they can have discretion and say, we don't even want to hear it?
Well, I think that's, I'd be lying to you if I didn't say it was an immediate concern when we picked up the case. But now we think the court will hear it. There's no discretion really under the errors and omission statute, but there are jurisdictional concerns. And one of the reasons why we're focused, so small, less is more, on court restrictions via felony convictions and court restrictions regarding guardianship orders, is that how can the court not want to administer justice? I mean, in other words, the court originates the court orders restricting the voters in these instances, and so the court has its own interest in ensuring that those are honored. Every contempt proceeding is about a person following a court order. So what are we going to do with these election officials? We're not going to hold them all in contempt. What we need to do is have a orderly process where the Minnesota Supreme Court says every election judge and the Secretary of State will follow these court orders. I'm more interested in just talking the broader implications of what Mr. McGrath and Mr. Seelig talked about. And that, that's kind of where we're at. The people are now pitched against their government because the government isn't delivering excellent government. And so the people are in a position where if we want excellent government, we have to fight for it. And it's a scrap, it's a fight, it's a brawl. And this is an example of a lawsuit where people have fought years for integrity in elections, and people don't understand why we just can't get it. And obviously the government has a problem acceding to the people's wishes, and so the people have to take charge. It's no different than other places, right, like Andy was mentioning. And I think the elections are so important because it's just a little shot into the soul of your government. And if your government can't run clean elections, well, you've got a problem with your government. And this is a frustration we're seeing on left and right with the government, and it's not going away. And in some ways, Minnesota, as Mr. Zorb said, is ground zero. Here was the highlighted in 2008, an election was determined by ineligible voters. And that was a history-turning election, and it was due to voters who were restricted by court orders voting. And are we going to put our foot down or not? And that's what this lawsuit's about.
Yeah, and I have one comment just to add to that. There's two high-ranking people in Minnesota that think that we have the best elections in the country. One is Congressman Keith Ellison, and one is Senator Amy Klobuchar. In fact, they think Minnesota's current system, now whether they understand it or not, I don't know, but they are both behind bills at a national level to make Minnesota's system of same-day registration a national deal, okay? But I don't want to get started on politics. We do try to, focus on election integrity. It shouldn't be a DFL or a Republican issue. It really shouldn't be. Ask Phyllis Kahn. Didn't she get into some battles where all of a sudden she wanted those verified? So, I think we're all going to be better off, I think, as citizens in our state if we can trust that the right person is in office serving us.
I wouldn't go that far. I think with the idea when you're doing this work on behalf of the people, that you have to remember that the government that you're suing is doing something wrong and intentional. So we don't trust our government anymore. We trust and verify. And the reason we have to verify is we find these things going on where they're not fulfilling their obligations, their constitutional obligations, their legal obligations. The time of trusting government officials is over. We've now moved into a period where we examine whether our government officials are fulfilling their obligations and their duties, and then if necessary, we call them out. We write a letter to the editor, we attend a hearing or whatever. And so it's very important to understand how many people support you in this room. The whole state of Minnesota supports the idea that our government officials must fulfill their legal obligations. This lawsuit, this issue has been around since 2008. All that taxpayer money gone into all these systems, and the government hasn't self-corrected. It's not necessarily all about elections. It's about, can our government self-correct anymore? Does it have the critical thinking skills to say, look, we're doing this wrong, we have to redo it? No. The government was happy with the 2008 result, and they haven't fixed any of it. And so what Andy's organization, Dan's organization, Minnesota Majority, have fought for since 2008 is, let's fix this. And the establishment says, no, 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 the illegalities continue. That's how bad our government is. And I'm not saying left-right. I'm saying they are left-right. That's why everyone, when I file these lawsuits, agrees with me, except the government officials I'm suing. Everyone in the room agrees. It's just the way it works. So this lawsuit is a winner. How could it be more vetted? It couldn't be more vetted. It is an absolute winner, and we're going to go into the Minnesota Supreme Court and see what happens. But you will be a witness. If we win, we're not anti-government. Beating the government in court is redemptive. It's redemptive. It saves the government when we beat them in court. And then if we lose, well, we've learned something else.
Yeah, one thing about accountable government too, and I don't know which literature, with all the research we've had, it's hard to keep track. One of the claims we have is that the Secretary of State violated, I believe it's Minnesota Statute 201091, which is crystal clear that said anybody who's registered, okay, that data is public, okay? So we've defined what registered means. If you're in the database, you are registered. Whether you're active, whether you're you have a status of inactive, deceased, deleted, whatever your status is, you are registered. So we asked the Secretary of State for all the information in the database, not just the public CD, because on the public CD, the only thing that they provide is people that are active. So if on Monday, you're in the SVRS, your records are in there, not who you voted for, but all your information, you're an active voter in the statewide voter registration system database. If the felony record goes to the Secretary of State, albeit after the election, and they send that data to the county auditor to update the SVRS so it says challenged felon. So the next day when you get marked challenged felon, that information they deem as non-public. Why should that be any less? And the statute is clear. If they're registered, we get the data through a Data Practice Act request. Well, guess what? We went to IPAD. We appealed that decision to IPAD, Information Policy Analysis Division. It's a government agency. Many of you are familiar with it, Dan, Carter. And we threw all the facts out. We disputed the cases that the Secretary of State's attorney, Burt Black, cited, and they agreed with us. It should be public data. Then we went, you talk about good government, Eric, then we went back to the Secretary of State and said, hey, IPAD, the Information Policy Analysis Division, came out with their opinion, they're all attorneys, nonpartisan, that they sided with us that that data should be public. And they said, well, to the extent that that data even exists, then they wouldn't even admit that it existed. It just gets, Dale, it gets worse and worse and worse. And then, so they wouldn't give it to us. So when we get to the Supreme Court will be able to get to weigh in on that also. And one of the things that I've learned through this process, I didn't go to law school, I would have probably failed, good thing I didn't. But is that the court's gonna say, have you exhausted administrative remedies in that particular claim? Absolutely. And we have all the supporting documents from IPAD saying, Your Honor, we went there, they agreed with us. And now IPAD's not a court, but what the law says, I believe, through Dan's, I've learned a lot from Dan, is that IPAD is not a court, but a court must give deference to an IPAD decision. Did I say that right?
Yes.
Okay, thank God. One more question.
Andy, I understand the monumental effort or requirement to hold the lower election judge in contempt, but can we, after this ruling, if it comes in our favor, is it possible to hold our Secretary of State in contempt if he fails to abide by the ruling of the court?
I think that you're so far ahead of where the legal system is. So, there's some novels I might recommend to you. Yeah, well, it's not where we are at the legal system. So right now where we are is we have to pick these strategies, less is more. And so in this case, by picking this discrete issue, we display for everyone to see what the values of our government are, and they're inconsistent with the people's values who merely want their laws enforced. And so what we do is we get the court order, we see if the court order is followed, but no individual election officer or the Secretary of State will be held in contempt.
Okay, thanks for coming, everybody, and we hope to see as many as possible at Old Mexico up on the other side of Como. Thank you. On the other side of Como.